All right, good afternoon, everyone. I'd like to call to order today's Thursday, June 8th meeting of the Missoula Board of County Commissioners. Please stand and join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Missoula County acknowledges that this event today takes place in the Aboriginal territories of the Salish and Kalispel people. Before we get going, Cheryl, do you have some announcements for us?
I do. I have a closed captioning announcement, and it's going to be up on your screen here just momentarily. Teams is being a little wonky for me here. Teams is not cooperating today. Yeah, it's not going to share screen.
Okay, we will forego the closed captioning announcement today.
Yeah, Teams is not cooperating.
Are there any instructions that you would like to give folks?
I can, it's not going to be up on the screen, but if you're joining us for this meeting virtually today, we will have closed captioning on all the screens here in Sophie Moe's room, and we also have assisted listening devices available. Please come to me if you would like an assisted listening device, and we'll get one for you. We ask that all speakers today please remember to speak slowly and clearly during the meeting. This helps with the accuracy of the closed captioning. There will be multiple chances during the meeting for public comment virtually. During those times, if you would like to speak, we ask that you use the raise hand feature. If you're on Microsoft Teams, this is the small hand button. If you're calling in on the phone, you'll need to hit *5 to raise your hand. Then once called on, you'll need to hit *6 to unmute. Thank you.
Thanks, Cheryl. We have two proclamations today. The first will be read by Commissioner Rivero, and that is for Juneteenth.
Thanks. Whereas Missoula County and the city of Missoula acknowledges the lasting impacts of racism in the United States, fueled largely by the horrific acts of institution of slavery, and whereas news of the end of slavery did not reach frontier areas of the United States for more than 2 years after President Lincoln's Emancipation Proclamation of January 1st, 1863, and months after the conclusion of the Civil War. And whereas on June 19th, 1865, Union soldiers led by Major General Gordon Granger arrived in Galveston, Texas, with news that the Civil War had ended and that the enslaved were free. And whereas African Americans have been slaves in the Southwest whereas African Americans who have been slaves in the Southwest celebrated June 19th, commonly known as Juneteenth Independence Day, as the anniversary of their emancipation. And whereas African Americans from the Southwest and across the country continued the tradition of Juneteenth Independence Day as inspiration and encouragement for future generations. And whereas for more than 150 years, Juneteenth Independence Day celebrations have been held to honor African American freedom while encouraging self-development, respect, and dignity for all people. And whereas the strength and character, faith, and resilience demonstrated by former slaves remains an example for all people of the United States, regardless of background, religion, or race. And whereas the character demonstrated by former slaves should inspire us in this country to give thanks for the freedom won by so many people in all nations and to strive for the goals of bringing freedom and democracy to people of other countries, no matter what their race or religion. And whereas although Juneteenth Independence Day is beginning to be recognized as a national and even global event, the history behind the celebration should not be forgotten. And whereas Montana proudly joins 47 states and the District of Columbia in observing Juneteenth as a state of ceremonial holiday. Therefore, be it resolved, we, the Missoula County and the city of Missoula, do hereby proclaim the 19th of June as Juneteenth Independence Day, to commemorate African American emancipation from slavery, to celebrate the freedom won by people in many countries, and to rededicate ourselves to the cause of liberty. Dated this 8th day of June, City of Missoula and the Missoula County Board of Commissioners.
Thank you, Anita. Is there anyone who would like to comment on that proclamation? Seeing none. Our second proclamation relates to World Elder Abuse Awareness Day. Whereas older adults deserve to be treated with respect and dignity to enable them to serve as leaders, mentors, volunteers, and vital participating members of our communities. And whereas June 15th, 2023 marks the 17th annual World Elder Abuse Awareness Day, recognition of which will promote a better understanding of this problem, which can include financial exploitation, physical or emotional abuse, neglect, and other negligent acts. And whereas the National Center on Elder Abuse, Adult Protective Services of Montana, Missoula County, Missoula Aging Services, and the Western Montana Chapter for the Prevention of Elder Abuse recognize the importance of taking actions to raise awareness, prevent, and address elder abuse. And whereas it is up to all of us to ensure proper social structures exist so people can retain community and societal connections, reducing the likelihood of abuse. And whereas preventing abuse of older adults through maintaining and improving social supports like senior centers, human services, and transportation will allow everyone to continue to live as independently as possible and contribute to the life and vibrancy of our communities. Now, therefore, we, the Missoula Board of County Commissioners, do hereby proclaim June 15, 2023 as World Elder Abuse Awareness Day, and encourage all our communities to recognize and celebrate older adults and their ongoing contributions to the success and vitality of our communities. Anyone want to comment on that proclamation? Okay, seeing none. Is there any public comment on items not on today's agenda? So for each agenda item that you see, for each of the public hearings, there will be an opportunity to comment on those items then. But this is your opportunity either in person in the Sophie Moise room in the Missoula County Courthouse or online to comment on anything else that you would like to that hopefully is within the jurisdiction of Missoula County. Okay. Seeing none, our current claims list is reflective of claims received as of May 16th through May 30th, 2023 by the Commissioner's Office, which totals $4,560,167.07. We have 5 public hearings today. For each of these, and this is particularly for any of you who have not attended these meetings previously, for each public hearing, we will begin with a staff report from Missoula County staff. That will be followed by an opportunity for an applicant or applicant's representative to make comments. We will then open it up to anyone in the room or online to comment. We'll close the public hearing. We'll have deliberation on the part of the Board of County Commissioners, of which there are just 2 commissioners here today. Commissioner Slotnick is unable to make it. And then we will deliberate and vote. So with that, our first public hearing is the Tucker family transfer. Zach. And welcome, Zach. Is this your first opportunity presenting to us today in this room?
You are correct.
Excellent.
Excited to get started. First, I need to mute my laptop. Okay, so the item I have today is the Tucker family transfer and aggregation. It is located at 8000 Nature Drive, which is in Lolo. The applicants are Gary and Rebecca Tucker. Their representative is Montana Northwest Company. And for the record, I am Zach Jones with the planning office. So this shows the location of the property. The red road to the north, or the top of the screen here, is Highway 12. The red road to the east is Highway 93. And then you have Mormon Creek Road just to the north, but the property is actually accessed from the subdivision to the east of the highlighted lot. And Nature Drive is the access point to the existing house that is on the property. And existing conditions on the property are just one existing home with a garage and a shop, which is accessed through a private access road, Nature Drive. And the property is about 153 acres. The proposal for the family transfer is to create 2 new tracts and then transfer the 3 tracts, which is the entire property, to the Tucker's 3 adult children, Jessica Overbaugh, Garrett Tucker, and Marissa Tucker, and also aggregate a boundary line that was created by Book N, page 550 of the deeds. And this is what that configuration would look like. The property is divided into 3 equally sized lots, each of which would be 51.216 acres, and transferred to the 3 children. And of the general evasion criteria and rebuttable presumptions that we review for family transfers, the only one that was triggered was this one, which is the division appears to be made for the purpose of speculation by the landowner or for resale for the benefit of the landowner by using the grantee as a straw person. This may be indicated if the grantor or recipient own other tracts of land in Missoula County, or it is evident that the receiving family members do not intend to reside on the family transferred tracts. And what came up here was that the applicants own another property that they live on at 6230 Lamar Trail. And Gary Tucker also co-owns with, I might be saying this wrong, Mackie Jody Lynn Tucker, 2 160-acre tracts that are north of Highway 12, west of Lolo. And none of the recipient adult children own any other tracts of land in Missoula County. So that is what I have for the staff report.
Okay, is the applicant in the room or online? Yeah, could you come on up to the microphone and the podium? There are a few questions that Zach will pose to you.
So first, could you state your name for the record, please?
And Gary, is your microphone on? The light should be green. You hit a little button there.
There we go.
Okay,
Gary Tucker.
thank you.
Okay. Did you buy the property with the intent of dividing it? Thank you. Do you or your transferees intend to transfer the property within the next year? Thank you. Have you talked to anybody at the county about going through subdivision review?
Have not.
Thank you. And all of the transferees are not minors.
Correct.
So will the properties be developed?
No.
Okay. And will the recipients of the properties be residing on the properties?
One parcel that has the house on it, daughter.
Okay, thank you.
Is there anything else that you'd like to add?
This has been in the family since 1921, and we'd like to see it stay that way. So
Okay.
that's why we're doing this.
Okay, once you hang on right there, I will open it up for public comment, which I am thinking there might not be that much. And I've got a question or two for you. Zach, anything else from you right now? Or does that conclude your?
Nope, that is everything that I
Okay.
have.
Or anyone from Montana Northwest?
Lynn told me she was not planning on being here today.
Oh.
She did say if you had any questions for her, we could call her.
Okay, so first off, is there any, and just hang on with us so I don't make you sit down and then pop back up again. Any public comment from anyone in the room or online regarding this proposed family transfer? Okay, so Mr. and Mrs. Tucker, you mentioned that one of your kids will be residing on the parcel that currently has a home on it. Thoughts as far as what the other two parcels will end up being used as? Do your kids have any intent of building homes there at some point?
Our son would like to at some point, and our daughter's young enough. I'm not sure what her plans are. Right now, it's, as you can see, it's going into a special needs trust with our granddaughter named as beneficiary. So our hope is to pass that on through the generations to her at some point. But time will tell.
Okay, thank you. Any questions, Juanita?
No, I don't have any questions. Thank you.
Okay, thank you.
I move to approve the use of the family transfer exemption. Oh, I'm so sorry. I'm reading it. It's different. I move to approve the request by Gary and Rebecca Tucker to utilize the aggregation exemption as presented in the subdivision exemption affidavit.
Second. Any further discussion on that first motion? Seeing none, all in favor?
Aye. And I also move to approve the request by Gary and Rebecca Tucker to utilize the family transfer exemption to create and transfer 2 parcels and the remaining parcel as presented in the subdivision exemption affidavit.
Second. Any further discussion on that motion? Seeing none, all in favor?
Aye.
Okay, thank you. Thank you, Zach. Our second public hearing is the first public hearing on a petition to alter a portion of Blue Mountain Road. Steve Nide.
Yes.
We have someone
Commissioners.
from the clerk and recorder's office first.
Okay.
Okay, come on up.
Hello, I'm Lisa Frost with the Clerk and Recorder's Office. A petition to alter a portion of the Blue Mountain Road has been submitted to the Clerk and Recorder's Office. It is described as Blue Mountain Road from the intersection of Tiberius Drive to the intersection with Forest Hill Lane. The petition fee has been paid in full and a notice of hearing has been published twice in the Missoulian. A petition has been signed by at least 10 of the freeholders of the Missoula County Road District. All affected landowners have been contacted. The purpose of today's hearing is to establish dates for the road viewing and second hearing, which Cheryl should have dates for those. And then just on a side note, we did have one opposition to the alteration.
Okay, thank you.
Thanks.
Steve.
Yes, Commissioner, Steve Nide, Surveyor's Office. As an older adult, some might say elder. Thank you for your elder abuse proclamation. So Lisa noted that there was one opponent. His name is Chris Newell. I reached out to him and asked him if he would be so kind as to provide me with reasons for his opposition. His reasoning was that he did not want to see Blue Mountain Road widened. That's not the intent of the petition. I responded to him, told him the intent was to not change the Blue Mountain Road, but to use the extra width petitioned for to create a non-motorized path. He got back to me and said, oh, well, that changes everything. I'm in support. And he, in fact, did re-sign the petition. He had signed it earlier. He re-signed it and sent it to me by email. And I'm not sure if it went to others, but I have it. So there is no opposition that I know of. All of the affected landowners have signed the petition and now approved it. And a little background on why this is being done is that there are plans to build a trail from the existing Lolo to Missoula Trail up the Blue Mountain Road to the Forest Service parking lot at the trailhead. And in looking at the right-of-way situation for that trail, it was apparent that the road that exists today is not entirely within right-of-way of record. However, there is right-of-way of record that does not follow the physical road. And initially, that 40-foot wide right-of-way that exists was looked at as the location for the trail. I and others looked at this as an opportunity to move that 40-foot legal right-of-way over to where the existing road is. I contacted the landowner whose road now exists. He was in agreement. He lives in Canada. I don't see him on Teams.
There is a hand up. I don't know if it's that individual. We'll find out here momentarily, but go ahead, Steve.
Yeah, Barry Strauss is his name. He owns the large lot northeast of the Forest Service parking lot. He decided that, yes, that was a good idea. It's of benefit to him. It takes away a burden of the old legal right-of-way, puts it on the existing road, and provides additional width to accommodate the trail. Based on all those facts, I created the petition, sent it to Barry. Barry signed it. Because he's out of country, I attempted to physically contact the adjacent landowners and also sent them mailings. I was not able to contact them physically when I knocked on their doors, but eventually I got the petitions back from all those individuals with their signatures. So that's kind of the basics here. And since we do have a hand up, let's see what's going on there.
Person's phone number who is 805-646-8051.
And before we do that, though, Steve, do you want to explain the process? So this is the first public hearing. There will be a road viewing, correct? And then we will reconvene and have the opportunity to actually take action, correct?
Correct. The road viewing has already been set for June the 12th. Juanita and I will meet in my office at 9:30 and drive out to the Forest Service parking lot at the base of Blue Mountain where the trailheads are. At that point, others can join in and we can do a required site investigation. We will come back from that investigation, draft up a brief report on our recommendation to the entire board. That will take place at the second hearing. And I don't know, do we have a second hearing date?
July 13th.
Okay.
July 13th would be the second hearing where the road investigators report will be read into the public record. Adequate time for additional public comment from anyone. And at that point, usually the commissioners can make a decision unless there's need for additional time for other input.
Okay, thank you, Steve. Let's begin this time online. Is there anyone joining us online or on the phone who would like to comment on this petition to alter right-of-way? Anyone online or on the phone?
It's Chris Newell. I don't know if you can hear me or not.
Yeah, go ahead, Mr. Newell.
Yes, I just wanted to confirm what Steve had said, that I had originally misunderstood the purpose of the change of moving the center line north to its actual location and the widening for the trails. So I just wanted to confirm that I do not object.
Great, thank you for that. Anyone else?
Yeah, thanks, Chris. And just because there was a little bit of confusion there, the purpose of this petition is to move the physical right-of-way to we're not anticipating in any foreseeable future road improvements other than building a non-motorized trail alongside the existing road.
Thanks for that clarification. Anyone else online or on the phone who would like to comment? Okay, anyone in the Sophie Moise room like to comment? Come on up to the microphone.
Hi there, Travis Mateer, Missoula County resident. I would like to speak just to general concerns about traffic flow and where we do know there is the future of growth happening along Mullen and also in Midtown. As I attend city, and I know this is county, but as I attend city development conversations in Midtown, I don't know if Big Flat Road and some of the growth and pressures of traffic are always being taken into consideration. I see a lot of reckless, stupid drivers on Big Flat more and more, and I get concerned as we have more construction happening in the city that people are going to try and take shortcuts if they think that there is some advantageous route on Big Flat. So I continue to get worried about my kids. The way they drive on the bus, McFlay or the McClay Bridge is also a continued concern. So I think public outreach and accurate information is more important now than ever, especially since we have such an atrocious media landscape, really not doing their job to inform the public. So please do your job to outreach to the public so they have accurate information about any kind of development happening on roadways. Thank you so much.
Thank you, sir. Anyone else here in the room like to comment on this proposed alteration of the roadway? Anybody else?
Is Michael trying to?
Is there the person who's on the screen identified as Michael? Are you wanting to comment? Okay, you're going to have to unmute yourself if you want to. Otherwise, there we go. Apparently not. It's going to say anyone online who does not want to be displayed in perpetuity in our records can turn off their cameras. So, all right. With that, we will keep the public hearing open. There will be a road viewing here in a couple weeks, and then we will reconvene in the month of July to take action on this. Thank you. Steve, you have not gone far from the podium here, but also Karen Baldridge, were you wanting to say anything more? Okay, so this is the second public hearing related to a petition to alter a portion of Lower Miller Creek Road. Steve Nide.
Yes, commissioners. A road viewing was held, attended by many. And I believe, if I'm not mistaken, some of the concerns addressed by those present were addressed at that meeting, one of which was speed. I think that was addressed adequately by the installation of a traffic circle that's proposed out there. So on May 22nd, 2023, David Strohmeyer and myself conducted this site investigation, and the report reads as follows. At approximately 4 p.m., the investigators listed above, that would be Dave and I, plus other representatives of city and county government, along with several petitioners and affected landowners, met at 7565 Lower Miller Creek Road. We discussed the different existing county petitioned rights-of-way and the section of Lower Miller Creek Road affected by this petition. Since the petition affects rights-of-way in both the city and county, both entities are collaborating to ensure continuous public right-of-way. We recommend the petitioner's request be granted contingent on the successful completion of the petition within the city and completion of a constructed road in the altered location and acceptance of that road by both the city and county. In addition, since the petition as submitted would result in an isolated section of Bitterroot Highwater Road across the Northwestern Energy parcel at 7565 Lower Miller Creek Road, it is recommended that with Northwestern Energy's consent, this section be included in the alteration. As far as I know and have been told, Northwestern Energy has offered that consent. That concludes my report.
Okay, we have received some public comment as of today from folks who felt as if they were not given adequate notice that this meeting was occurring, and they asked for additional time to participate. Is the applicant or the petitioner or a petitioner's representative here or online?
I see Josh Hilling up there from IMAG.
Josh, are you there?
Yes, I am.
So well, first off, question for Cheryl. So when would be the next available date that we could take this up if we wanted to not take action today?
We have June 22nd available or July 13th.
So Josh, if this was postponed until June 22nd to give folks adequate notice, how would that impact your construction schedule?
I don't believe that would be impactful to us.
Okay. Hold that thought. Anyone in the Sophie Moise room want to comment? Come on up, sir.
Yeah, so I'm Scott Twite, one of the owners of the property. And I was just curious as to what additional information was requested or wasn't presented at the time. Do we know what additional information is being requested? And
I don't think there was any additional information requested so much as folks who did not know this meeting was happening today.
Okay.
John or Steve, to my knowledge, nobody requested additional information to be presented so much as just wanting to participate.
Yes, not to my knowledge either, no additional information was requested. The two individuals that emailed a group of us about receiving individual notice of this second hearing were both in attendance at the first hearing, and that second hearing date was established in the first hearing. So I believe, unless they weren't paying attention, they would have been able to know about today's hearing. And it seems to me that that was their primary issue, was that they weren't individually noticed of this second hearing.
John Hart.
So I received a voicemail this morning about 10 o'clock from a woman named Deb Hoagland, asking me to tell her the county's legal position on why we don't have to give actual notice to affected landowners for every single hearing on a road petition. And I was able to respond to her with an email a couple of hours ago explaining that, these road statutes are old statutes. Honestly, I was surprised to learn this afternoon that we don't have to provide any actual notice to anybody on a road petition. The only time that our obligation to provide actual notice, when I'm talking about actual notice, it's like mailing something, sending an email, putting it, knocking on your door and giving it to you. So the only actual notice requirement under the statute is after you make a decision, then you're supposed to notify affected landowners of the decision, and for what that's worth. That's what I told Ms. Hoagland. I copied the statutes from the code into my email, and I told her, I said, but if you or anybody can make it to this meeting today, you can ask the commissioners to continue the hearing to another date and postpone their action on this petition. And, I said I couldn't speak for you, but I suspected that that would be something that you would be receptive to. I didn't get a response prior to this meeting. I haven't got it during the meeting either. So that's what I did.
Thank you, Mr. Hart. Come on up. Got to come up to the microphone. And
So I can speak to you.
Okay, please state your name for the record and keeping us in suspense there while we're talking about you. Okay.
Well, I always like to know what's being said before I raise my hand. My name's Deb Hoagland, and I can speak for David and Renee Biggert today because I just got off the. I've been communicating with them back and forth, and they were the ones, and they can't be here today because when you said if we weren't paying attention, well, people, people have hearing issues, and so, and I kept looking on the commissioner's website because I thought, well, when is it? And so, and your agendas weren't published till I don't know when, just recently, because I looked all the way through May and they weren't published. So I don't know exactly when they were published for the agendas were going to happen. And then I looked on Sunday and I was like, God dang it, are you kidding me? Because I didn't know that it was on the 8th. And when we were here the last time, you in particular said that you would keep us informed, that you would send us letters. And we can go back and we verified our addresses. And you even made the comment of, you want me to pay postage for that? And it was like, yeah. And so that is what you agreed to. And I could be here today, but the others couldn't. So I would like to ask for a postponement for their benefit.
So is there anything specific you would like to share about the proposal today while you're here?
I have lots.
Oh, okay. Well, go ahead.
Do you mind?
Yeah.
So because I don't know if you want to postpone it till the other participants can be here.
It's a public hearing. You can comment on it today, and then we can decide whether or not to extend it or not. So.
Okay.
And if you could keep your comments to 3 minutes or less, that would be.
It's not going to happen.
Well.
3 minutes or less.
Well.
Give them to us.
I can, because.
Yeah.
I have them written out.
Okay, you can provide us your written comments, and if you wanted to provide a summary in 3 minutes, that would be good too.
I can give you I can give you the basis for my comments.
Excellent.
I won't give you a summary of the comments, but I'll give you a basis for the comments.
Okay.
So I'll do a 3 minute part, and then I'll do a little thumbnail for the rest of it. How's that?
Go ahead.
So, I understand that development is a reality and a necessity, but I also believe that this petition cannot be looked at in a vacuum in which it's presented. The proposal needs to be assessed within the context of the Miller Creek Area Comprehensive Plan Amendment, which is the current legal neighborhood planning document guiding Missoula City and County planning and zoning. This proposal should be evaluated on the merits of the goals, design principles, and recommendations of the comprehensive plan, of which this petition appears to disregard. The transportation services and infrastructure are a large portion of the comprehensive plan. One of the tenets listed is that, and I quote, "The current residents of Miller Creek do not want to bear the traffic impacts of new development." I am emphatically stating that this petition will make me bear a significant impact. Besides the obvious impact of dramatic increase of volume of traffic, which is going to happen, but relocating the eastern portion of Lower Miller Creek Road will negatively impact my property and quality of life dramatically for 2 reasons. First, car headlights will now shine at my property as compared to the headlights moving past my property as they do now. Miller Creek is one of the last few views in the Missoula area where night skies aren't grossly impacted by city lights. I have somewhat made my peace with the lights of the development that are coming. However, I shouldn't have to suffer the insult of additional headlights aimed at me. Secondly, as there are numerous slide-offs and winners now on Lower Miller Creek Road, I believe that adding a new curve adjacent to my property will increase the likelihood of property damage. Given that the developer owns all the property where the change is proposed, there is no reason that he could not tie the egress from Linda Vista Estates Phase 3 to 5 further west and avoid impacting the enjoyment of my property. And there are other reasons that this comprehensive plan, so more in a thumbnail, I don't believe that the comprehensive plan is being adhered to on many, many conditions of this, both of the development, which is city, but coming out of the development as well. You don't take into account all the requirements of the goals, design principles, and recommendations already in there. For instance, such simple things as bike paths. Bike paths is in here shall be considered throughout the whole. And the other thing about coming from the city to the county, in this comprehensive plan amendment, it keeps saying bring existing and new roads at the same time for traffic flows. That you have to look at the sum total, not just of this little stretch, but you have to look at that whole stretch of Lower Miller Creek. I don't believe you were here last time, but last time I said, and this is one thing that I really want on record, is right now, buses coming southeast, school buses, southeast on Miller Creek, making that 340-degree turn onto Lower Miller Creek, cannot stay in their lanes. They have to turn headlong into the eastbound traffic. That whole section of road has to be looked at. You can't just look at this one little part. And again, and then the other short thing that I'll say, because that comprehensive plan states over and over and over that you have to look at the existing and bring them up to safe standards at the same time as you're doing other development. And the other thing I'll say though too, so that the bike, that's a heavily used bike road. What provisions are being looked at for that?
Thanks.
It's a heavily used pedestrian road. That has to be factored into this. I don't think you can look at 1,000 feet of it and say, oh, we're just going to change this tiny thing. You're chipping away at the basic tenets of that design plan. And then the last thing I'll say is in it talks extensively about conservation areas.
And just so for clarification, are you citing the city or the county's growth policy?
City and county. It's the plan. It's on the Missoula County City Planning Zone site. It's the neighborhood plans that they have listed there.
Okay.
And it was done in 1995. This is 30 years that there's been this guidance out there to make bike trails, to make safe pedestrian ways, and I don't see it throughout that new subdivision, which is not your problem, but coming out of it, it is your problem. So the last thing I want to say is about the conservation areas that this plan says that you must consider. And as well as, what's the word? Not pathways. Here, let me, corridors, wildlife corridors. It says you must consider it. That valley out there, last winter I counted 135 elk right along the road, and sometimes they go up the hills that are being developed. I find it very fascinating that the Mount Jumbo can be closed to even hikers in the winter to protect the elk. But the South Elk herd, not so much.
Thanks. We got to wrap up here. So if you could provide your written comments to Cheryl, we will decide here in a second whether we will extend this public hearing or not. Thank you. Anyone else like to comment on this? Yes, come on up.
Thank you. So I am Shira Scott, Clerk and Treasurer Director, and we are in charge, our office is in charge of evaluating the petitions for road alterations and also for providing notice. And I just want to acknowledge Ms. Hoagland and Mr. and Mrs. Biggert's concerns. and acknowledge that we understand that it can be challenging to keep track of those dates. And even though we're not required to provide notice by law, I think in efforts to promote access to government and transparency, that we can do better. And so our office is committed to revisiting our processes for providing notice, and will amend our practices moving forward. So my apologies. Thank you.
Thanks, Shira. Steve Nide.
I just want to make a general comment. Missoula County maintains a YouTube channel in which anyone can go and review previous meetings. I did that this morning when I first got word of this dissatisfaction. So I would invite others to maybe review what actually took place at that meeting. And maybe you want to hear more about or review and renew when something's going to take place that was scheduled at a previous meeting. You can certainly go to that YouTube channel. It's great. I forgot a lot of things that was said at that meeting too. So
Okay, thank you. Anyone else who has not commented already would like to comment on this particular item? John Hart.
I'm going to say a lot of unpopular things today. I thought I was going to save them for the last agenda item, but
I'm sure you will have more unpopular things to say then
I'm
too.
going to start right now.
Okay.
First, though, I don't think Shira Scott needs to apologize in any way. I mean, I was surprised to learn this afternoon that the actual notice that we give to affected landowners of a petition is more than is required by state law. So they're already going above and beyond what they're required. I applaud them for looking at their procedures, but I want people to recognize they already do more than is required. And that's a theme with Missoula County. The second thing, and I don't want to color your decision on whether or not to continue the hearing until another date, but I think it's important for people to understand the state of the law when it comes to roads and widening roads, building roads, developing land at the end of roads. And what I try to remind myself is of the case that came out of the Montana Supreme Court in the early 80s here in Missoula County, when the State Department of Transportation decided to widen and improve Reserve Street, which before that had been a country two-lane. And many property owners along Reserve Street understand, reading the tea leaves, seeing what was going to happen to their quiet neighborhood, sued the Department of Transportation and Missoula County. And the Supreme Court said this 40 years ago, and it's still good law today. I'm going to read from the decision. The benefits which come and go from the changing currents of travel are not matters in respect to which any individual has any vested right against the judgment of the public authorities. To say otherwise would allow any property owner or resident of land adjacent to a public roadway to file legal claims against the governmental agency responsible for the maintenance and construction of the roadway whenever a vehicle traffic upon the roadway increased to a point where the resident owner objected. This is not the status of the law in this area. We sympathize with the plight of the landowners. However, the wheels of progress, I can't scroll down. The wheels of progress shall not be slowed. There is no doubt that increased traffic volume, traffic fumes, noise, dust, and difficulty of ingress and egress caused inconvenience or discomfort to the property owners when the Reserve Street Bridge was opened. Nonetheless, we find these detriments to be non-compensable. That's a passage that I don't really like that myself. I like quiet streets, I like quiet neighborhoods, but that's the law in this area. And that's what, like it or not, should guide your decisions on road issues.
Thank you, John. Any further public comment online or in the room? Okay, discussion, thoughts?
Yeah, I appreciate reminding us of the law and clarifying. And at the same time, especially since Josh Hillian said it wasn't going to be detrimental to their work, I'm fine with extending it.
Yeah, it appears as though there will be no material harm to the project. So we will go the extra mile and extend this to June 22nd. And that will be, please spread the word, Ms. Hoagland, June 22nd back here, and we will be making a decision at that point. Okay. Thank you, everyone. We will move on to our next public hearing. You need to come up to the microphone, please.
Sorry. I just wanted to know, since I've handed it, I can't imagine adding to my comments that I already handed in written.
Yes.
I don't need to revisit any of that at the next, correct?
No, it's in the public record and we will
Okay.
consider that in our decision.
And yes, thank you.
Yes, thank you. Yes, sir. Come on up.
So Scott Twite again, and I would assume that that would be something we'd have access to so we can address it
Absolutely.
previous to the meeting and the comp plan and stuff. I have some
Yes.
things that I would like to
And
clarify on what she said.
it will be attached to the meeting materials, but also Cheryl or Steve, could you specifically get those?
Absolutely.
Okay.
And just to let everyone know, the meetings are published a week before the scheduled date.
Okay.
And we will also ask our staff to address how growth policies either in the city or the county apply or don't apply to petitions such as this. So thank you. All right. Thank you, everyone. We will move on to our fourth public hearing of the day. This is a resolution related to no parking along Highway 200 in the area of the Sharon parking lot. Our Chief Public Works Officer, Shane Stack, is joining us. Shane, would you be so kind as to provide a staff report?
Yeah, so on May 25th, I believe, we opened the public hearing regarding the proposed no parking resolution for Highway 200 and a short portion of Speedway in the Sharon area. I'm assuming you can see my screen okay?
Yes.
All right, so the proposal, as you can see on the map, was to create a parking restriction on Highway 200 between Brickyard Lane and Lurch Lane on both sides of Highway 200, and then also a short segment of Speedway Avenue between Highway 200 and Buttercup Lane, which is a short segment of the county portion of Speedway. We had two public comments on Missoula County Voice page. There was an opponent to the restriction, and their concern is that if the parking lot, the new newly constructed or being constructed parking lot is full, then they wouldn't have a place to park. We did have a proponent on Missoula County Voice. Those are the only two comments. MDT, my visits with them, they are in full support of a restriction of parking on Highway 200 in this location, and they are willing and ready to install no parking signs if and when this resolution is passed. And as a reminder, we do have a 68 spot parking lot that should be opened June 17th. I think June 16th is the last day of construction right now. It'll have, again, 68 spots. I did a quick calculation with each spot being equal to 24 feet of length on Highway 200 if people were going to parallel park, and that essentially stretched from the intersection of Speedway Avenue all the way to Lurch Lane. And so the equivalent parking that we're putting out there today would be essentially all the parking that would be able to occur on that, call it that southeast side of Highway 200. So that's the information that I have. And I guess turn it over to you, commissioners, for your thoughts.
All right. Thanks, Shane. And thanks for that calculation. That's useful information. So anyone in the room in the Missoula County Courthouse want to comment on this item? Anyone online or on the phone like to comment? Seeing none, we'll close the public hearing. Any questions?
No, also appreciate the calculation and the visual.
Okay.
It's been a long time coming, so I wish Slotnick was here.
Yeah, it has been a very long time coming. We've heard for years, if not decades, complaints about safety and parking along this section of Highway 200. And as we did farther out towards West Riverside and the Confluence State Park out there, we created parking and then posted no parking signs to keep folks from parking in areas where they should not park and divert them to the areas that we've created for parking. We're doing the same thing here. And I think this is a creative solution that's been a long time in coming, has been a collaborative effort between multiple government agencies. So I'm glad to see this come to pass.
Well, with that, I make the motion to close the hearing on Highway 200 Cheyron.
Okay, how about
and
want to adopt the resolution?
and
too?
adopt the resolution
Okay,
as
I will
well.
second that. Any further discussion on adoption of the resolution? Seeing none, all in favor?
Aye.
Aye. All
Thanks
right.
so much,
Thanks,
Shane.
Shane.
Thank you.
Commissioners, I think our final hearing is going to take a little while. I know that, sad as it sounds, I have a lot to say. There's a lot of folks in the room, I think, that want to say something. There's plenty of people online. Maybe we should take a 5-minute break and then come back and start this last final action item.
Okay, we will recess until 3:05. So take a break and we'll come back shortly.
So wise. Thank you so much. I'm going to take it.
We can't hear you, Dave. I think may have to unmute the Sophie Moise room.
Roll up here.
Now we
Can you hear us now?
Yep.
Okay. Thanks everyone for that short recess. We will come back into session as the Missoula Board of County Commissioners, and we will begin with a staff report from Deputy County Attorney John Hart related to the Macaulay Meadows subdivision settlement agreement and release claims.
Thank you, Commissioners. I'm here with my co-counsel, Deputy County Attorney Dylan Jakes, again to talk about the Macaulay Meadows subdivision. I am not as old as Steve Nide. I don't need the protection of elder abuse proclamations, but I am I'm getting up there, and I have a sheepish confession to make. I have never put together a PowerPoint presentation in my life. I'm not an early adopter. I actually thought about it a little bit before, and then I thought, no, I want to retire saying that I've never done a PowerPoint presentation. But I do have Cheryl and Violet here with a couple of visual aids to help me. And the one that we have up on the screen right now is an outline of the property that is the proposed and ultimately denied Macaulay Meadows subdivision that is the subject of the lawsuit we're going to be talking about today. So for those of you that can see, hopefully, the outline of this property is circled by the green and black dashed line. And this is a 28.3 acre parcel of land. And the proposed subdivision was for 14 lots, dividing this property. And as I talked this afternoon, you know, roughly half of the property is pasture land at the base of Macaulay Butte. And roughly the other half of that is what I'll call the apron of Macaulay Butte. It doesn't go up to the top of the butte, but it is that northern apron of the butte. And you can kind of see a line going from northeast to southwest through this property. That is the Missoula Irrigation District ditch. And that visually divides this property between what is roughly flat pasture land and the apron of Macaulay Butte. So the proposed subdivision was to divide the property into 5 lots on the Butte portion and 9 lots in the flat pasture land with several acres of, well, maybe not several acres, but more than 2 acres of common land or common area. You denied that subdivision application on April 22nd, 2021, unanimously denied it. The basis for that decision, in a nutshell, was that you found that there was a failure to mitigate the loss of about 11 acres of land in the subdivision that is prime agriculture soil. You found that there was a failure to mitigate the loss of wildlife habitat, notably bird habitat, that exists on the Butte apron portion of the property. And then finally, you found that the totality of the subdivision application was not in substantial compliance with Missoula County's growth policy, our land use element, and the target range neighborhood plan, local plan as part of our growth policy. And then also the city has a cornerstone open space plan of which Macaulay Butte is part. And together, reading all of those growth policies together, considering the loss of ag soil and bird habitat, you found that the proposal was not in substantial compliance. On July 14th, 2021, the developer sued Missoula County over that decision. The lawsuit alleged that your decision was arbitrary, capricious, and unlawful in violation of the Montana Subdivision and Platting Act. The lawsuit also alleged that in denying the subdivision application that you violated the applicant's constitutional rights to equal protection and due process in violation of the 14th Amendment to both the federal U.S. Constitution and the Montana State Constitution. The lawsuit then finally alleged that the result of your decision to deny development constituted an unconstitutional taking of the applicant's property without just compensation, and that is that was in violation allegedly of the 5th Amendment to the federal and Montana State Constitution. The relief that the applicant asked for in that lawsuit was, one, an order from the court ordering that the denied preliminary plat be approved. So in other words, asking the court to order the subdivision application that you had denied. The lawsuit also asked for attorney's fees and costs that the developer incurred in litigating. And then finally, the lawsuit asked for money damages as a result of the allegedly unlawful denial. And I don't want to wonk out on the money damage part of that. The applicant wasn't required to go into great detail. And frankly, I can't necessarily articulate what money damages might look like as a remedy if this lawsuit would be successful. But I mean, for the sake of simplicity, use as a measure of damages the difference between the property as it is now and the difference in the value of the property as it's subdivided into 14 lots as proposed. The difference in those two values, the development value obviously being higher, would be one measure, one simple measure to think about in terms of money damages. And I don't know what that number is, but I think it's a not insignificant number. And that's a risk for the Missoula County taxpayers. So following along in the timeline, December 2nd, 2021, following briefing from Dylan and I, the district court here in Missoula County dismissed the lawsuit, saying that they had failed to timely file the lawsuit and that they didn't have, that their constitutional claims were not proper in this particular context. That's what the district court decision found. So, I mean, dismissed. Lawsuit goes away, Missoula County wins. The developer appealed to the Montana Supreme Court. And on November 15th of 2022, so almost a year later, the Montana Supreme Court unanimously reversed the district court's decision and remanded or sent the lawsuit back to district court to hear the merits of the lawsuit. So that the Supreme Court's decision had the effect of actually just sort of start, we would be starting over again. So as of November 15th, Missoula County needed to respond to the merits of the lawsuit and litigate the case. The decision notably was by all 7 members of the Montana Supreme Court. That's unusual. Generally, the only 5 members of the court hear and decide a matter, but all 7 Supreme Court members, again, reversed the decision, and it was a 34-page order, which is, that's not a really long court decision, but it's getting into the realm of being pretty detailed on issues, you know, on a motion to dismiss that probably could have been dispensed with in, I don't know, 12 to 15 pages, half of the pages. And in reading that decision, you know, I've been doing this for a long time. I've read hundreds and hundreds of Supreme Court decisions in my 25 plus years of practicing law. And as I read that decision and I read what the court said about the developer's lawsuit, I was concerned that the Supreme Court was sending a message to Missoula County that we had some infirmities with the decision that had been made. And notably, the court went out of its way and talked at length about the fact that Missoula County had, in part, denied this subdivision for failing to protect agriculture soils when our subdivision regulations didn't have any guidance for how a developer would go about mitigating such a loss. And the court seemed, the way the decision was written, the court was very troubled by that. And you know, I talked to my colleagues and they had the same concerns. And so what I did, trying to be a responsible attorney for Missoula County and for the taxpayers, I initiated discussion with the attorney for the developer, and I just came right out. I have a good relationship with this individual, and I came right out and said, "Is there? Do you want to talk about a possible settlement of this case?" And That led to several discussions, some of which involved Tim Worley in our planning department. And over the course of the next several months, we were able to put together what myself and my office and Dylan felt was a very reasonable compromise settlement proposal that we were ready to bring to you and to the public. And before I get into the details of that, I also want to talk about something else that changed between April 22nd, 2021, the date of your decision, and November 15th, 2022, the date of the Supreme Court's decision. One thing that happened is the Montana legislature changed the Montana Subdivision and Platting Act to take away any power that local governing bodies have through reviewing a subdivision to require a subdivider to set aside important land that has important ag soils or extract some sort of monetary contribution from the developer in lieu of not setting aside important ag soils. So to the extent that your decision in April 22nd of 2021 was a valid reading of the Subdivision and Platting Act, by July 1st of 2021, all subdivision applications going forward no longer had any obligation to try to mitigate impacts to important ag soils. So we had a very troubling decision from the Montana Supreme Court, and we had a very significant change in the law, which, pulls out one of the three legs of the stool that was the basis for your decision to deny the subdivision. That also, the change in the law also, in my mind, undermines whether or not that subdivision proposal was in substantial compliance with the various growth policies on which were in effect at the time of the application. So, I'm not saying the second leg was ripped out too, but it's wobbly, which really left the principle worth fighting over if we were going to litigate this case, that being the impacts to wildlife habitat on the butte and the view shed of the butte. It's kind of this framework that I had when I approached Defense Counsel and had throughout this past winter and early spring in negotiating a settlement proposal. And also, I think about this every day, all day long. I try to think about saving the taxpayers some money too. And I saw some significant risks litigating this case. So on May 9th, last month, I brought to you at a public meeting a memorandum of understanding that I had negotiated with the plaintiff and plaintiff's counsel in this case that set up a framework for hearing a proposed settlement of this case. And there were three exhibits to that MOU, one being a proposed preliminary plat for a new subdivision. And Cheryl, if you could at this time bring up that preliminary plat, it's not styled as such, it's styled as a site layout. But this is Exhibit A to the MOU. And you can kind of see the outline of the aerial that Violet had on the screen to this point in time. But this shows a new layout for a subdivision we're considering today. It is still 14 lots on the same 28 plus acres of land, but instead of having 4 new lots on the butte, for a total of 5 developable lots on the Butte. We're down to 1 additional lot and the existing lot that's on the Butte. The additional 3 lots that were part of the litigated proposal have been brought down into the pasture flatland part of the property in the area that was common area and that was going to be set aside as a common area and protection of important ag soils.
I'm sorry, John, or can someone, I can't see this very well. Can you just with your cursor show us where those new lots are and where those, which you were just talking about?
So there are, again, you see the squiggly line that's
thanks,
the
Tim.
irrigation ditch through the property, dividing the pasture land from the apron of the Butte. The 2 lots then above to the north of the irrigation ditch are the Butte lots, and then the other 12 lots are in the flatland to the north of the irrigation ditch. So lots 13 and 14 are on the apron of Macaulay Butte. And just for the record, there has been a structure, a residence that you can kind of see, roughly there in the epicenter of this picture. I mean, some of the residents can correct me if I'm wrong. I think that residence has been there for decades. I know that this past summer it was demolished, but it is still a lot that has had a structure. And again, correct me if I'm wrong, someone. I want to say that house was either red with a white fence around it or white with a red fence around it. Well, the point I'm trying to make is it was real visible and it's been there for decades. It was demolished, but if you agree to this settlement, that lot will, well, in any event, that somebody can rebuild on that lot today, even if nothing happens after this meeting. The only new development on the Butte would be on lot 14, which is the lot that's in the far southwest corner of this site layout. And part of that, much of that is delineated and will be delineated on the final plat and in covenants as a no-build zone. So I think the part that would be developed is what is above the trees and then just
I'm sorry,
immediately below
lot
the lot
13
line.
is in the southwest, right?
Yeah, lot 13.
Okay.
Did I get them backwards?
I think so, but you keep going. I gotcha. Yeah.
Anyways, okay. I'm sorry about that. Well, it ain't lot 7. I know that much.
This is lot 7. He was talking about southwest.
Yeah. Is that lot 14?
That's lot 13. This is lot.
Okay. Okay, so I got it right.
So lot 14, lot 13.
Thank you, David. So this site layout was Exhibit A to the MOU. The second exhibit to the MOU was proposed conditions of approval on the final plat. And those were Tim Worley in the Planning, Development, and Sustainability Department took the lead role in drafting those conditions with edits from the developers team. Most of those conditions are conditions that were part of the subdivision that was denied. So they're not new, but there are many that are new and they're significant. And I'm not going to go through every single condition of approval. You'll be relieved to hear, but I want to highlight those that I think are very pertinent to your decision today. Again, instead of 4 additional lots on the Butte, the conditions of approval and preliminary plat allow only one additional lot, and neither lots 13 or 14 can be subdivided in the future without Board of County Commissioner approval. That will be in the covenants. Those covenants will run with the land. So unless this commission approves a further subdivision of lot 13 or 14, those will remain as the only two lots on the butte in perpetuity. And again, one of them has been developed for decades already and will have a new home on it that will be subject to significant architectural restrictions. Condition of approval number 21 involves building design requirements, again, for lots 13 and 14. And the goal for these were to harmonize any development of those two lots such that they will harmonize with and blend into the butte. So there are exterior structural material limitations. Any development has to use earth tone colors. White is specifically prohibited. There's no reflective, you can't use windows with reflective glazing, and there's many other restrictions that I'm not going to go into. There are exterior lighting restrictions that direct all lighting downward to reduce glare, light trespass, and sky glow. Again, these are on the two lots 13 and 14. These architectural restrictions and lighting restrictions will be incorporated into the covenants. They'll run with the land, and they will specifically be enforced by county's planning, development, and sustainability department, such that they will be subject to review prior to issuing a building permit as part of the zoning compliance review. So any development that happens on lot 13 and 14 won't be approved unless they comply with these restrictions. So that is, again, the second exhibit to the MOU being the conditions of approval, the lengthy conditions of approval. The third agreement, or the third document, is what's before you actually for signature and consideration today. And that is a settlement agreement and release of all claims by the developer against Missoula County. And the terms of the settlement, and I want to read these into the record, are as follows. The terms are in section 1 of the settlement agreement. Section 1.1, Missoula County approves, by signing this, you're stating this: Missoula County approves the preliminary plat of the McCauley Meadows subdivision in a configuration and form as substantially shown on Exhibit A. Exhibit A is on the screen right now, and with an effective date as of the date of execution of this settlement agreement and release of all claims, and imposes as conditions of preliminary plat approval the conditions set forth in Exhibit B. Those are the 7 pages of conditions that I just highlighted. Section 1.2, upon receipt of written approval of the preliminary plat and associated conditions as specified herein, Titan, that's the name of the developer, shall within 7 business days dismiss its complaint against Missoula County in the 4th Judicial District Court with prejudice. Section 1.3, Titan acknowledges, as the applicant for the subdivision, that it bears the burden of satisfying the conditions of preliminary plat approval to obtain final plat approval in accordance with the Missoula County subdivision regulations. And finally, section 1.4, Missoula County acknowledges, as the local governing body with authority to review and approve subdivision applications, including final plat applications, that it will process any future final plat application for McCauley Meadows in good faith and in accordance with Missoula County subdivision regulations. So if you approve this settlement agreement and release, you'll be approving the preliminary plat on the screen and you will be requiring the subdivider to dismiss the lawsuit against Missoula County. And if the developer wants to file a final plat for this subdivision, comply with all of the conditions of approval and bringing that final plat through Missoula County's process, the same review process that we use for any other subdivision, and ultimate approval by the governing body. And this isn't really here nor there, but we would also go in front of the district court judge, and the district court, we would ask the district court judge to approve and adopt this settlement proposal and order it as such. And I don't anticipate that the district court would have any other function going forward, but the district court would have some jurisdiction should there be some very significant disagreement between Missoula County and the applicant as this moves through to final plat. But I don't anticipate that. The MOU very, very importantly included the requirement for a public process. That was very important to me. It was very important to the developer that we do this in the sunshine with ample public notice to everybody and make a final decision up or down on the record. You commissioners know that in settling lawsuits, there is a very narrow exception in Montana law that would allow us to have the discussion that we're having right now in a session between myself, Dylan, the commission, in a closed session. You would not be able to ultimately make the decision to settle in a close, but having this frank, candid discussion about the pros and cons of settling a lawsuit can be done behind closed doors. We're not doing that in this situation. And it was very important that we do this in the sunshine and not rely on that statutory exception to open meeting laws in Montana. So we crafted into the memorandum of understanding this public process, and as part of deciding how extensive to be, I made the decision that I'm going to write a letter following that May 9th meeting. I wrote a letter and I sent it to 39 property owners and organizations, including every single individual and organization that commented on the denied subdivision at any of the several public hearings that we had on that subdivision. And so everybody those people got notice. Every adjacent landowner got a letter from me. And we also sent that notice to the Target Range Homeowners Association, the Audubon Society, the Community Food and Agriculture Coalition, and the Target Range Sewer and Water District. And my letter told people that there was on our county website how to find a page on the Missoula County Voice that had all of these pertinent documents. The MOU, all 3 exhibits to the MOU, the complaint against Missoula County, and a copy of the decision of the Montana Supreme Court. Those were all provided on the Missoula County Voice page, and they've been there for almost a month now. And my letter went out, I think, the day after May 9th. It might have gone out on May 9th itself. I can't remember. But that was important to me, to reach out to people and let them know. And so we have received several written comments. And because everyone's tired of hearing from me, I'm going to let Dylan summarize for you the written comments that we have received up to this point.
Thank you. Dylan.
Good afternoon, commissioners. If you can hear me here. For the record, I'm Dylan Jakes, Deputy County Attorney. I went on maternity leave right around the time the Supreme Court opinion came out, so I've been less involved in the settlement sort of discussions, but coming in the last couple months. And so I'm just going to really quickly just summarize public comments here. John mentioned the Missoula County Voice page, and it's been up since that MOU. You approved the MOU. And just as some quick stats, it looks like we had about 110 total visits to the page, with around 33 people who have engaged in some form with the documentation that was posted. It looks like about 6 of those people posted comments, and then we also got a couple email comments. So if you bear with me really quickly, I'll try to just summarize what those comments consisted of. So the first commenter was Stuart Goldberg. Their stated interest was that they were a donor of some of the conservation easements on the Butte. They're opposed to the settlement proposal and note that they are specifically opposed to building on the Butte and are concerned about the effect on the community's conservation efforts. The next commenter was Tom and Amy Franzen. I should also say, if there's anybody in the room that I am summarizing your comment and you later in the public comment portion want to clarify what I've said, I've done my best to summarize, but please do clarify if you have other concerns. Tom and Amy Franzen are adjacent target range landowners. They are opposed to the settlement proposal. They note that they're concerned about the plan for water use and the possibility of future landowners taking more water than they're supposed to, thereby affecting adjacent home water supplies in their existing wells. They're also concerned about the level of research that's been done around groundwater movement in the area, noting that standing water accumulates in the nearby flat near the spring and the potential effect that sewage produced by the subdivision could have on adjacent landowners' existing wells. They also note a concern for the cultural significance of the Butte that couldn't be returned if developed, the effect on wildlife, conservation efforts, and the effect of removing one of the only established sections of trees on the north side of the Butte, also the eyesore and the effect on the community. And finally, they're requesting that Lot 13 be removed from the proposed preliminary plat. The next comment was from Paul and Sid Ferguson, who are target range landowners, and they're opposed to the settlement proposal. They note that they're opposed to building on the Butte as an iconic feature of the area, and they're concerned about the effect on the viewshed and wildlife. And they also have significant concerns about water and waste. The next commenter was Brett Kalina. Brett had, I think, 2 comments that I've compiled into one summary here. Brett is a target range landowner and contributor to the adjacent river frontage conservation easements. Brett is opposed to the settlement proposal, noting that they're opposed to building on the Butte due to concerns that it would negatively affect the adjacent properties protected by a conservation easement, including the effect on wildlife, and that the landmark would be forever scarred. Also concerned that the preliminary plat proposal under the settlement is not different than the original preliminary plat proposed. And finally, concerned that the county settling the case could encourage litigation in other cases of denied subdivisions. Just a few more. The next commenter is Kim McGuire, a target range landowner who is opposed to the settlement proposal, noting that they're opposed to building on the Butte and concerns about conformance with the target range neighborhood plan and wildlife habitat. The next commenter is Edward Taylor, who didn't state their interest or specific position on the settlement proposal, but they did note a concern about the wildlife regulation portion of the development and who would enforce those requirements. The next commenter is Leslie Dalla Piazza, who's an adjacent target range landowner, is opposed to the settlement proposal, noting they're opposed to building on the Butte, and they have a desire for the area encompassing Lot 13 to be put into conservation. They also noted that issues related to previous denials were really the reason for delay of the development. And the final commenter, name was Peggy. We didn't get a last name. Interest was not stated, but they are opposed, and they concurred with the other comments. That summarizes it.
Thank you, Dylan. John, anything else?
You'll be relieved to know that I'm getting close, but I have some more to say.
Okay, excellent.
And Dylan probably said it, but that summary includes comments we received like up to noon today. So it's my strong recommendation, and my office's strong recommendation that you sign the settlement agreement today. And the reason I say that, I'm going to go through several points in support for that recommendation. This proposal complies with our zoning regulations. It complies with the Subdivision and Platting Act. It complies with the Subdivision and Sanitation Act, or it will have to comply with the Subdivision and Sanitation Act, or there will not be a final plat, and every other law and regulation applicable to land use decisions of this kind. And that was very important to me, and it was very important to the developer and the developer's attorney. I was, from the very first discussion, I was not willing to, and nobody was willing to bring a settlement proposal or talk about a settlement proposal that was not 110% in compliance with Montana law. I didn't want to do that to you. I didn't want to do that to the citizens of Missoula County. And I certainly didn't want to go in front of the judge and have to tell the judge that we were fudging the law in order to get a case settled. I believe that this is a significant improvement in terms of development on the Butte. I acknowledge that the ag soils, for all intents and purposes, are lost, but the reduction from 4 additional lots on the Butte to 1 additional lot, I think, is a very, very significant concession by this developer, and shows the good faith that they had. And frankly, it's about as much as that I would have hoped for in bringing a settlement proposal to you. And I actually applaud the developer for doing that. Another reason, as I've said before, we can't, in any future subdivision proposal or land use application for this piece of land, we can't do anything to preserve the ag soil. That opportunity is come and gone. The 2021 Montana legislature did away with that. So that's off the table. Also, in my humble opinion, and I feel strongly about this, so I don't think this is going to be used against me someday. I think if you were to deny this proposal, if it came to you as a subdivision application, I think the denial would be arbitrary, capricious, and unlawful, and in violation of Montana Subdivision and Platting Act. And I want you to understand that even if we continue to litigate this lawsuit and we are ultimately successful in defending the lawsuit, this property owner could submit another subdivision application that has more development on the Butte, and you might have to approve it. So if you reject this settlement agreement proposal today, you might be in a position of having to consider a proposal with significantly more development on the Butte and have no lawful choice but to approve it. And that's even if we are successful in this lawsuit. Alternatively, Missoula County could lose the lawsuit and the court order the denied application. And so we would be back to a subdivision with 4 additional lots on the Butte. Any potential scenario for more development would come with no ability or limited ability to have many of the conditions that this subdivision will have on it, including we would not be able to impose a no further division on lots 13 and 14, like the proposal has today. We may not be able to impose the architectural and design restrictions on new buildings on lots 13 and 14. And we may not be able to impose all of the living with wildlife covenants that will be on this land either. And there are many other conditions of approval that we were able to negotiate that may not be part of a subsequent proposal for this subdivision. Again, as I've said before, and this is, I'm going through the support for my recommendations in summary. This would eliminate the risk to the taxpayers of a money damages judgment against Missoula County. Another thing I want you to be aware of, this property owner or a subsequent property owner could create one or more lots on the butte through a family transfer, which is exempt from Subdivision and Plating Act and exempt from subdivision review. Now, I don't know the family of the property owner, but if they have parents, if they have a spouse, if they have children, any combination of that, they could divide the existing tract into several developable lots on the butte, and Missoula County may not have any ability to deny that subdivision or that exemption application. And again, well, I haven't talked about this, but unless there's a philanthropist or a group of philanthropists who wants to try to buy out the current owner, this land is going to get developed eventually, even if we win this lawsuit. But today, you have an opportunity to put significant restrictions and limitations on that development. And so again, it's my strong recommendation that you sign this settlement agreement. I have a proposed motion that would be to authorize the chair to sign the settlement agreement and release of all claims between TITAM LLC and Missoula County. And unless Dylan wants to add anything, that would conclude the staff presentation.
I don't, just that I concur in, John's assessment of the situation and this case, and he's worked really hard to bring this to fruition. So yeah, nothing else to say.
Thanks, John and Dylan. That may go down as the most thorough Deputy County Attorney presentation ever to be revealed in this chamber. So thank you. Okay. Would anyone from TITAM or TITAM's legal counsel or representative like to present? Mr. McCormick.
Good afternoon, Commissioners. Alan McCormick, attorney with Garlington, Lana Robinson, representing TITAM. I appreciate what truly was the most thorough Deputy County Attorney presentation I've ever participated in. In the 20 years that I've been practicing land use law, I've participated in what's getting close to about 70 pieces of litigation, and those have all been for counties. I've represented every county in western Montana except for this one on a land use item, from everywhere from Gallatin County to Cascade County up to Lincoln and down to Ravalli. And so that has given me great appreciation for the job that John is doing. I've sat in his seat and advised county commissioners throughout western Montana on their risks associated with land use law litigation. And we have litigated many of those through to the end with the Supreme Court, and we have negotiated resolution in all of those. Conversely, I've only filed litigation on behalf of developers against local governments 4 times in 20 years. And that's all given me the context to appreciate what you're going through today, and it's a mitigation of risk. And John is quite capably presenting all of the issues that appear in front of you, and litigation is a risk, and it's unpleasant. And so it's given me the context, and the reason that I bring that up is because of the context, to say I was very, very pleased when John reached out after the Supreme Court order and asked if we would be interested in discussing resolution of this case. I was even more thrilled, frankly, when I contacted our client with the idea of making some concessions and trying to find a good compromise. And they willingly said, yes, of course. So we spent several meetings with and conversations with John and Tim, all of those in good faith and in the spirit of compromise to reach the documents that you have in front of you, including the conditions of approval for the preliminary plat. It's notable, we did not ask and did not seek for you to approve and ultimately the court to approve a final plat of the subdivision. What we're asking for is to have our client put in the position that TITAM expected to be in, which was to have a preliminary plat approval. And so TITAM will still have to bear the burden, as is noted in the settlement agreement, of complying with all the conditions of approval. And also notably, we did not include a request in the settlement terms for award of attorney's fees, for the cost in bringing the litigation, or for damages. That was not something that our client was asking for, simply wanted to be put back in the position that originally expected to be in, but with concessions. And John mentioned most of those concessions, certainly reducing the number of lots on the butte, reconfiguring some of the other lots, but then also agreeing to significant conditions of approval related to architectural controls. I think County Attorney's Office would acknowledge that the architectural controls are something that we asked to be included. Tim had included some in the initial draft of those, and the ones that we suggested are much more stringent than the ones that the county had proposed, because that's our client is interested in making sure that the two dwellings that would be on that area are architecturally appropriate for that context. So again, I appreciate your consideration of this. I appreciate the position that you have been in, having sat in John's chair many times doing this sort of evaluation. I hope you will consider his recommendation strongly, and certainly I recommend that we all execute this settlement agreement, put the litigation to bed, and feel like we've made the right compromise. I will answer any questions that you have. I also have with me Andy Mefford of PCI, who can answer any technical questions that you might have about the design or the conditions of approval as they're recommended here. Thank you.
Thank you, Mr. McCormick. So we're 2 hours into our meeting today, and what I would encourage folks to do is be as succinct as possible in your comments. We're going to open it up to public comment here in just a moment. I would encourage you to keep your comments to 3 minutes or less, and we are going to use an analog tool here. We're going to use an hourglass. I think this was seen in The Wizard of Oz, perhaps, and this will help you keep track of your comments and where you are in the 3-minute cycle. For those of you online or calling in by phone, we're going to exhaust the comments in the courthouse Sophie Moise room first, and then we'll go to folks online who want to comment also. Use the raise hand function if you can to indicate that you want to speak, and we'll call on you in the order in which you raise your hand. I think with that, and I would just say, if you hear someone who already has said what you were going to say, it's okay to say, I agree with that, and no need to belabor the point. We may have short memories, but I think we can remember long enough to remember the previous speaker in a meeting like this. So with that, if you have comment, come on up to the microphone, make sure that the green light is on, state your name for the record, and share with us your thoughts.
My name's Webb Harrington. I live on Schwenk Court, which is adjacent.
Is your microphone on?
Good question.
Is there a green light showing?
It was green.
Okay, yeah, just bring it a little closer.
My name is Webb Harrington. I live at Schwenk Court with my husband, and I've commented on this subdivision since its inception, pretty much opposing it, mostly almost 100% because of building on Macaulay Butte, which is so important to the whole community. But John, you've done an amazing job today of changing my mind, and just an appreciation for the work you did to not only honor the residents, but the property owners, which I believe they have a right to develop their property. I just didn't like the way they proposed developing their property because it would be an infringement on not only Macaulay Butte, but the wildlife, et cetera, everything you've listed in your thing. But you've done a good job, and this is a compromise that I could accept. Lot 13 is still a big issue for me because I believe it's unnecessary. But the alternative of not settling this and going forward and having it more disastrous up there is appalling. And I appreciate the work your office did, and not to bemoan this, but I appreciate you, the commissioners' help through this process of stopping what could have been a disaster from the initial plat. So, thank you.
Thank you.
Deb, thank you. I wish I had as much influence with my daughter as I do with you in arguing a point.
Sir.
Hi, I'm Jim Brown with Five Valleys Audubon. We think that the proposed settlement is very reasonable. I would like to commend you for adding the clause on downward pointing lights. Macaulay Butte is in an important migration corridor for birds that comes along our river corridor and down the Bitterroot. And lighting has become known now as one of the biggest disturbances of migrating birds there is. So it would be good to even do that elsewhere along this river corridor to the extent possible. But thank you for including that.
Thank you. Next.
Yeah, my name is Mark McQuirk. I border the property. I think you're giving a little bit more credit to your settlement for the wildlife because they are going to be affected. There's no question, even with these considerations that you've given. This year alone, I have seen herons, cranes, turkey vultures, bears, a wolf, turkey, deer, hawks, eagles, and marmots on that property. They're not going to be there because a lot of them are on that corridor. I'm not necessarily against what's going on for that reason. I'm just trying to protect them. My biggest reason is being on the border of it. I was part of that part of the house that was torn down. They tore it down and I think it was earlier this year. It was horrible. Dust, noise. I've been there 20 years plus. And I can't imagine 14 going at once. Is there any restriction on how many they can build at a time? They're going to build it. I don't care. They've already started the sewer process, or not the sewer process, excuse me, the power process out there. But I can't imagine. I think there's two that border mine. Are they going to start those at the same time, bordered right against me? The noise is incredible. The dust was incredible. Excavators pounding. And that was just a tear down of one property. I'm not here to prevent it. I'm here to try and make it easier for me to live through this crap. Thank you.
Thank you, sir. Next, come on up.
My name is Leslie Dalla Piazza, and I'm an adjacent property owner, I guess is the classification. I'm opposed to the settlement, primarily because of the Lot 13 on the Butte. And while I appreciate the concern for my tax dollars, every iteration of this proposal has gone down in part because of building on the Butte. And so I feel like if the developers were as committed to a development that could garner support from the neighborhood, they would have saw their way clear to not, the existing lot is an exception from my perspective, because I agree it was there when any of us bought our properties and built our own homes. But the addition of a lot on the Butte is, it's beyond the pale for me. And I'm in agreement with the gentleman who talked about the wildlife. You know, we have the luxury of being able to see, as we sit on our front porch with binoculars, all of the animals up there. And I would include coyote in the list that he provided. I have concerns about the water and the sewage, but I I, not being a scientist or an engineer, can't really address that. And you're suggesting that that has properly been addressed within Montana law. So I guess the final thing I would say is that I don't personally give the developers, owners, any credit for, the compromise that has been made on this development. I'm in agreement that this is probably the best we're going to get. Two concerns are that, one, your proposal states that those lots 14 and 13 can't be further developed or subdivided unless it comes back before this body. Well, if there are commissioners with more of a development mind, they'll be right back here putting more houses on the butte. So it's not protected in the way that maybe some of us would like to think it's being protected with this agreement. And it would be nice if there could be something more concrete, more final, more permanent that precludes any additional building on the butte. And I guess the other thing I wanted to say is that since you're saving all of our taxpayer dollars by not going to litigation on this, perhaps we could use some of those to buy lot 13 and put it into conservation so that it does not get built on. Thank you.
Thank you. Anyone else in the room like to comment? Erica.
Hi, Commissioners. Erica Grindy, Chief People and Risk Officer. Somewhat of a serendipitous moment for me to come up. As you know, Commissioners, but I always think it's important to try to help the public understand the financial risks in these situations. So I'm not going to go into, where we would find those financial risks, because I think John has done a great job of explaining what could happen. But I do think it's important for you to remember and the public to understand that Missoula County is self-insured and what that means. For litigation such as this, this would fall under the county's liability insurance. The county is self-insured, retaining $1 million of any damages that are awarded. And what happens is the county has a risk fund. Those dollars are restricted for the purposes of funding claims, be those liability claims, property damage claims, cyber liability claims. So in this case, that first $1 million would have to come from that fund, or if that fund doesn't have that level of reserves, we would have to go out for a judgment levy. Anyone in this room who has a property sees a couple of judgment levies already on their tax bills at this time. And so I just want to make sure everyone understands how it would be funded, and that that's what we're talking about when we're saying we're saving taxpayer dollars. So I'll let you provide any further information in terms of savings that the county might have, but in terms of actually funding this, that's how it would occur.
Thank you. Other folks in the room who would like to comment on this, come on up to the microphone. Okay, anyone online or on the, folks, don't be shy. If you want to say anything, hop right up and come to the microphone.
My name's Paul Ferguson. We live on Glen Drive. And the street there has a lot of potholes, which at times are visible from outer space on Google Earth. And we've had Rangich 1, Rangich 2, Macaulay Lane, all the heavy equipment coming up. The road is in terrible shape. The county won't do anything about it. So would it be possible to divert the heavy equipment to Humble instead of Glen Drive?
Thank you, Mr. Ferguson. I do not know the answer to that question, but
and I'd like to recommend that John did a good compromise.
Okay, thank you, sir. Anyone else in the room want to comment? Is there anyone online via Microsoft Teams or on the phone who would like to comment on the settlement proposal? Okay, yes, Liz.
Hi, this is Liz Bile. Can you hear me?
Yes, we can. Go right ahead,
All
Liz.
right. Well, I am adjacent property owner. I also want to thank Mr. Hart for all the work that he's done. That was just great to see, just the considerations for the area. I wanted to agree with Mr. McCork on just the question of timing with construction, as far as if there's any way to mitigate some noise pollution as this goes down. I realize obviously there will need to be developments and construction noises during this process. And then agree also just with the comment of questioning as far as the roads, adding more traffic and having a small 2-year-old with already people driving really fast in the area, and just thinking about sort of if there's any possibility for, there's no sidewalks, they're very wide roads, but as far as trails or things like that, or a sidewalk being able to be put in, thinking about safety and walking in the area. So that's all I have to say. Thank you.
Thank you, Ms. Bile. Anyone else online like to comment? Going once, going twice. Okay, we will close the public hearing. And questions from the commission?
Does Alan or John or Dylan or Tim Worley have any responses to folks' concerns that Mark McCork or Leslie De La Pilla raised? Can we answer any of those concerns?
I can't. I don't want to impose a sort of a build out schedule, or I don't want to commit to using particular roads or, for whatever development and, and heavy equipment is accessed on this road. If there's other specific concerns that I missed, maybe I could address those, but I can't address those.
Does anyone else? We'll come to that question in just a moment. Anything related to the build out. So I will say that we have very limited, if any, jurisdiction over pedestrian infrastructure off-site related. Correct me if I'm wrong, John, but there's no way that we can add conditions to a subdivision that might address significantly off-site improvements. Is that?
Well,
I think I was hearing part of that in one of the comments, that in the general area there might be inadequate sidewalks, pedestrian infrastructure.
Yes, that's not a condition that we're imposing on this particular subdivision. There are some pedestrian paths along Ringo Drive that will have to be built out for this subdivision, but otherwise there isn't any additional non-motorized infrastructure, I don't think.
Okay. All right, no takers.
Sorry, thanks.
So I do have a question, John, as far as lots 13 and 14 and the requirement that any further future subdivision of those lots would require BCC, Board of County Commissioners approval. What sort of review, presumably that would likely be a minor subdivision. What sort of review process would that look like? Because I think the commenter is correct. There's no way we can bind the decisions of future commissions when none of us are sitting here. But just in terms of the process by which those would be divided.
So the wording of condition 19 is as follows. The covenant shall include a provision prohibiting further division by subdivision or subdivision exemption of the two southernmost lots, 13 and 14, subject to PDS review and approval. This section of the covenants, and these covenants will be covenants that run with the land in the sense that as the lots are sold over time, every purchaser will buy that property subject to that covenant. This section of the covenant shall not be amended or deleted without prior approval of the governing body. So as I see procedurally, what would have to happen is that an owner of lot 13 or 14 would have to bring up, would have to petition this body to approve of an amendment to those covenants. And I believe also, and maybe Alan will correct me, I think in order to amend or delete that covenant, that property owner would need the support of every other lot owner in this subdivision in order to go forward with that amendment. So everybody who owns a lot in this subdivision would have to say, yep, it's okay with me to amend or delete that covenant. And then the property owner would have to petition this body demonstrating that support and convince this body that that covenant should be either amended or deleted so they can go forward with whatever subdivision proposal they would want. So it would be a very heavy lift. But Leslie's point is well taken. You can't. This commission decades from now may look very different. Who knows? The Missoula Valley may look very different. But it still would be a very heavy lift to remove this restriction. And for that reason, I can't imagine making it, crafting it in a way that's even more onerous or more difficult than it is already.
Thanks. And a simple head nod will do. Mr. McCormick, are you in concurrence with Mr. Hart's appraisal of the covenants there? Come on up to the mic. It's more than a simple head nod, apparently. So,
Alan McCormick, never expect an attorney to do a head nod because it's just not in our DNA. I wanted to say close enough, but then I know you would ask me the question, well, why are you not saying absolutely? The only quirk I have to that is that covenants typically do not require 100% approval because for all the many things that you might want to do, you don't want to let that one holdout control the show. So typically, most covenants require a 75% or at least a 66% approval to change the covenants. But John is absolutely right about everything else. You'd first have to get all of the, whatever that threshold number is to approve, then they'd have to come back before you to approve. And only if you revoked the covenant could they then file for an application for a subdivision. It's probably going to be a subsequent. Would it be a subsequent minor or would it just be a major? So it could have more than just a minor subdivision review attached to it. One of the nice benefits of this design and removing those lots off of the hillside is that you're not going to see additional construction on the roadway that leads up to that additional house. And so that means there's no new cut to the hillside. There's some benefits to that. And any additional lot's going to require that kind of additional work and the like. So it's I agree. This is what I'll agree with a head nod. It's a very heavy lift.
Okay, thank you for that clarification. Any other questions?
Did Tim want to add anything?
Tim Worley, is there anything you want to add? He shakes his head no, but then he proceeds to the microphone.
That was a shake yes.
Tim Worley with PDS. On the non-motorized, John is correct. There's no requirement for off-site non-motorized connections. The only scenario where that would be the case is if there's existing non-motorized where there's a gap, they would be required to fill in a gap. But as far as extending anything from this subdivision, there would not be a requirement. All that's going to happen is an 8-foot wide pathway will be built along the extension of Ringo Drive. So, and that's contained internal to the subdivision.
Okay, thank you. Anything else, Juanita?
No, you're itching.
No, I will show my hand. Folks, I think this is as good as it gets. Am I wild about this subdivision? No, I think that's borne out by the fact that we denied it previously, but since then there have been significant changes afoot, as John Hart mentioned. State law has been changed. One of the major reasons for denial previously has been taken away from us. This has gone to the Supreme Court, which has remanded it back to district court, and the Supreme Court has telegraphed to us, as again John Hart has thoroughly made clear, the Supreme Court has telegraphed to us that they would probably not be inclined to agree with some of the defense claims that we've been making at this point in time. The risk that we run by not accepting this settlement agreement is finding ourselves with something much less desirable to the community than what is currently here before us. So I think this is probably, again, as good as it gets, and a sound decision, and anything contrary to that would likely be subject to being arbitrary and capricious decision on our part. Commissioner Vero.
And that we have Erica Grindy in the audience, it gives me pause as well. So our chief people and risk. I'm glad you came up, because we would have asked you to come up and talk about the risk to our taxpayers. I appreciate the work that went in to create this compromise. I know it's really difficult, but I don't think we've experienced a subdivision denial like this that's gone to the Supreme Court, come back, and still all parties have agreed to work together. So thank you for that. Alan, thank you for reaching out to John. So I'm in agreement with Dave. Are you making a motion?
No, I'll leave it up to you. There it is right there.
I authorize the chair to sign settlement agreement and release of all claims between TITAM LLC and Missoula County.
I will second that, and I will, council is wanting to
Can I
interject.
say one more thing? And
Yes.
I want to say this to the residents out there in Target Range and the adjacent property owners. I mean, I appreciate everybody's comments. And before I dove headfirst into this, I want you to know that I spent a little time out there, and there is really a hush to the land right there, especially notably during the gathering darkness of a mid-December evening. And I appreciate that the volume of that hush is going to go up a notch or two, especially as it's built out. And I was very cognizant of that. I visited this and I spent some time out there because I didn't want to be, as a public servant attorney, I didn't want to be a participant in something that I couldn't live with myself. And so thank you for all your comments, and thank you for, helping me try to get the absolute best compromise settlement we could for this very nice corner of Missoula County.
Thank you, John. Thank you, Dylan. Thank you, TITAM and legal representation by Mr. McCormick in the settlement talks. Thank you to all of you in the audience and online and elsewhere in the community. You are the ones who provided support throughout the litigation thus far. And again, this is not necessarily the outcome that I had hoped for, but it is an outcome that I think is one that we can live with and is as good as it gets, as I said previously. So we've had a motion, a second. Any further discussion? Seeing none, all in favor?
Aye.
Aye. Okay, that concludes our business for the day. Thank you, everyone, and have a good and safe rest of the evening.